Hello everybody. We are going to be talking about bankruptcy law today. My name is Thomas Weeks and we can get the presentation started. Today's agenda, we will be looking at the history of bankruptcy law. I have some slides put together that show the early bankruptcy acts that we can take a look at. We will compare individual and business bankruptcy. We're going to describe the types of business bankruptcy. There are a few different options for individuals as well as sole proprietors and corporations. We can pull up a few notable business bankruptcies from any of them that went through Chapter 7 to all the way to Chapter 13. And then we have a slide that talks about some of the ethical implications of bankruptcy. So, history of the bankruptcy in the United States. Originally, the framers of the Constitution modeled the law from English law, which was pretty pro-creditor. He did not want to file bankruptcy in England in the 1700s. The first version of the Constitution gave power to the government to create law. So right when they first created our Constitution, we knew we needed to have a bankruptcy law, but we didn't have anything in place for over 10 years. Many states actually beat the federal government in creating this law. Many of those states were also pro-creditor. They wanted to make sure that the creditors got paid what they were bargaining for. They also required prison sentences for some of the violators. So there was the Bankruptcy Act of 1800. That's the actual first Bankruptcy Act that our country adopted. It was very pro-creditor and could only be creditor initiated, meaning that the debtor could not say, I want to proceed for bankruptcy. It didn't end up working out and was repealed 3 years later. And it took a very long time for the next act to come out. The Bankruptcy Act of 1841 was the next act that came around, and this was the first time debtors could file for bankruptcy and receive a discharge of debt. Law was criticized by creditors, claiming that too few payments were ordered and too many discharges were granted. It was very pro-debtor at this point, and it seemed like the difference between the Bankruptcy Act of 1800 and the Bankruptcy Act of 1841 was made up basically pro-creditor and then pro-debtor. Then we finally came to the Bankruptcy Act of 1867. This was the first bankruptcy law that allowed for involuntary individual bankruptcies. It was very detailed and covered a variety of situations. So as the acts grew, they started adding many different situations and basically became more detailed as time went on. This act, though, had much of the same shortfalls as the previous versions. Either they were too pro-creditor or too pro-debtor. Finally, we have the Bankruptcy Act of 1898. This is the first bankruptcy law that basically became permanent. This has been amended and replaced many times since then, so it's not like this is truly the law that we still use today, but since this act, there's always been a bankruptcy law in place in this country. We had the Bankruptcy Reform Act of 1978. This was comprehensive and sweeping change to the bankruptcy law. This is a pretty milestone case as far as bankruptcy law goes in the United States. It brought into effect what we know today as the Bankruptcy Code. And really what this did was give a lot of power to the bankruptcy judges to make, to use their discretion to make decisions. So after the Bankruptcy Act of 1978, we have the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. What was significant about this is it introduced means testing for determining which debtors qualify for bankruptcy and which are, they have the cash flow to be able to maintain their payments to the creditors. What this also did on the individual side, it required mandatory credit counseling and debtor education for individual filers. Individual versus business bankruptcy, they actually are very similar. They overlap quite a bit. The most notable difference is individual bankruptcies require a means test. Businesses can cancel debt contracts if it is financially favorable for both debtor and creditor to do so. Uh, Oftentimes in Chapter 11, that comes to play. They'll just decide that debt contract no longer makes sense, and the creditor may decide that this is something they can go ahead and terminate. There's also another factor in individual bankruptcies. There are some debts that are not dischargeable in bankruptcy court, mainly federal student loans. That's going to be the big one. If you go to school and you pull out $150,000 in student loans, you can't decide to file bankruptcy 2 years later and basically wipe away that debt, and then 10 years later you'll be scot free. The types of business bankruptcy, and I think it would be beneficial to look at the definition of bankruptcy. I went from website to website and really found Investopedia's definition to be quite accurate. It states a legal proceeding involving a person or business that is unable to repay outstanding debts. The bankruptcy process begins with a petition filed by the debtor, which is the most common, or on behalf of the creditor, which is less common. All of the debtor's assets are measured and evaluated, and the assets may be used to repay a portion of outstanding debt. The first form of business bankruptcy would be considered Chapter 7 bankruptcy. This is often referred to as total liquidation bankruptcy. This is the best choice when businesses have no future. It's used when the debts of the business are so overwhelming that restructuring is not an option. This is often used if the business is an extension of the owner's skills and they don't really have a lot of assets involved with them. So, in a small corporation setting, if a painter's company, an art company decides to file bankruptcy, really they don't have a lot of significant assets in the business, but the majority of the business is based off of the artist involved. A trustee is appointed by the court to take possession of any assets that are available, and they are to distribute this to the creditors. This does result in a discharge for the owner of the business. Partnerships and corporations do not receive a discharge. Chapter 11 bankruptcy. This is probably the most common as far as corporate bankruptcy goes. This is the best choice for a business that has a future. Really, what it is a business develops a plan to reorganize and continues operations. They're going to reorganize under a court-appointed trustee. In some cases, the owner of the company may actually be the trustee in this situation, just depending on what the bankruptcy judge sees fit. A plan, they're basically trying to create a plan that outlines how it's going to repay its creditors. Creditors will vote on the plan, and a bankruptcy court will either approve it if they find it fair and equitable, or they'll send it back for reorganization. Another thing that the judge will look at is whether or not the creditors see this as a mutually beneficial decision. This chapter in the bankruptcy code can be extremely complicated and can take over a year to complete. Most of them can take up to 2 years. And another thing to point out is not all Chapter 11 bankruptcies are approved. Some of them just flat out can't get approved, and then they end up going down the Chapter 7 route. Chapter 13 bankruptcy. This is usually used by individuals, but can be used in a lot of the sole proprietor situations. So many of the businesses out there that organize as a sole proprietor can find this beneficial. It's similar to Chapter 11 in that a plan is created and reviewed by a court. So really, the individual or sole proprietor is putting together a plan on how they're going to repay, this debt. Are they going to restructure the time that it's going to take? Are they going to restructure the payments or the payment amount? The plan details repayment in that it's looking at the repayment amount, it's looking at the repayment time frame, and really it's dependent on income. So if you have enough money in your cash flow to pay your current debts, maybe what it would do is extend the amount of time that you have to repay it. So oftentimes it stretches out payments to 20 years. The main benefit in Chapter 13 bankruptcy is you can avoid losing personal assets such as a house or any of your personal property. This can be very beneficial in sole proprietor situations when you're looking at all of your assets as a whole, and that's including your business assets. It can help protect the things you find most valuable, such as not losing your home. Chapter 12 bankruptcy. This really is very similar to the Chapter 13 bankruptcy. What the main difference is this applies specifically to family farms. Really, it's taking into account the unpredictability of the farming business and the seasonal nature of it. It's designed to let farmers have some leeway in keeping their financial flexibility so they can reorganize debt in the case of a drought or in the case of something bad happening on the farm. It will allow them to keep their farm and keep their livelihood for the future. Mervyn's is a clothing retailer who originally filed for Chapter 11 bankruptcy protection under the bankruptcy code. Later, they realized that there really was no option to restructure their debt, and after attempting to close some of their stores and scale down some of their operations to maintain profitability, they ended up filing for Chapter 7 bankruptcy, which liquefied all their assets and required them to close operations. They ended up shutting down their entire store. Recently, however, the Mervyn's family bought the intellectual rights of Mervyn's, and they are going to start up a online clothing retailer in the same name. But Mervyn's eventually succumbed to the Chapter 7 bankruptcy and liquidated all their assets. And this guy might look familiar. Donald Trump has had multiple businesses file bankruptcy on his record. I could probably spend 20 minutes talking about the companies that he had that filed bankruptcy, but really the one I'll bring up today was the Trump Taj Mahal in 1991. Basically, the Trump Taj Mahal casino opened in Atlantic City, with Trump financing the completion of the construction with $675 million in junk bonds at a roughly 14% interest. By the following year, the casino itself was in debt to the tune of $3 billion, while Trump owed some close to $900 million in his own personal liabilities. In order to keep the casino afloat, Trump tried to restructure the debt, and he struck a deal with his lenders in which he basically gave up half of his ownership share and equity in his casinos to make sure he can maintain his casino without it folding. He ended up also selling his 220-foot yacht and basically put himself on a spending limit. That was a good example of filing for Chapter 11 bankruptcy, in which he wasn't going to cease operations. The Trump Taj Mahal is something that's still around today, but it allowed him to maintain operations. some ethical considerations to wrap up this presentation. We have a few of them. So the first ethical consideration that I'm going to bring up are companies in financial distress are continuing to leverage large purchases. So for the example with Mervyn's, they knew that they were in financial distress, but they tried to buy their way out of it. They continued to purchase higher end stock and stock more of it to hopefully hit a sales streak and continue operations. Personally, I think this is something that could be considered unethical when you are knowingly in a situation where you are in financial distress, especially with some of your key stakeholders, which are basically your shareholders. They're basically not they're not knowing the situation that you're in, and when you continue to make these large purchases and know that you have a way out with bankruptcy, I think that's something that should be considered unethical. Another ethical consideration that I found very interesting was the executive compensation during reorganization. So after companies file for Chapter 11, oftentimes they'll look at all their debts that they have, and some of the debts that they actually put on their books are executive compensations. Now, most of these executives will actually take this debt to themselves and kind of put themselves up on a pedestal and say, I'm doing something very good by not taking this. This is something that I feel like is kind of misleading, because this executive compensation shouldn't even be brought into the conversation when they're dealing with financial distress. That should be the first thing that a company should consider cutting, is this executive bonus structure. Another thing that I found interesting is creditors can charge a risk premium when lending money. So in a situation where, like Trump's Taj Mahal, he ended up selling more or less junk bonds at a 14% interest rate. There's a reason why those were at 14% interest rate, is because this is considered a very risky assumption. With companies that have employees can't necessarily charge you a risk premium for working for you. So let's just say a company goes into a financial strain, an employee can't come up and say, hey, this is considered risky for me to work for you. I am going to only work for this amount of money. It's kind of not a two-way street in that situation, where the creditors are protected, but not really the employees. And then the other thing kind of ties in with the first ethical consideration, but a lot of companies will delay reorganization to achieve internal milestones. So if an executive has a bonus coming up, what they'll try to do is delay this reorganization of their debt to make it seem like they're more profitable and successful, and hopefully increase their stock, and then it'll end up coming back on them a few months later after they achieve their bonuses, where they will announce that they're filing for Chapter 11 bankruptcy protection. That basically wraps up the presentation that I have for you today. I did use several references that you guys are more than welcome to check out here on the slide. If you guys have any other questions, feel free to email me. My name, thomas.weeks@emmu.edu. Thank you.